Lords. I appear with Mr. Heaton and Miss Bird for the appellant. My learned friend Mr. Bunting appears for the National Union of Journalists, and Sir James Eadie, Mr. Fichenna, Mr. Milford, Mr. Bethel and Ms. Kelleher appear for all the respondents. My lady, I hope that you've got a distressing quantity of documentation, a core bundle, a supplemental bundle, and a number of authorities. And I hope yesterday the court also received an agreed chronology, which is an updated version, and also a glossary that's been agreed between the parties.
Yes, we did. Thank you very much for those.
If it hasn't been filed already, the chronology is going to go in core tab 34, and the glossary is going in core tab 35. If the court is working electronically, an electronic version has already been prepared.
Thank you.
Subject to the court, the parties have also agreed a timetable, which I hope the court will see.
Yes. Well, there's a lot of ground to cover, obviously. Quite a short period of time.
Okay, there is. What I propose to do is I propose to cover 5 points in my submission. First of all, I propose to make some introductory points and also summarise the submissions that are made by the appellant. My second topic will be the scheme of the Investigatory Powers Act. The third, the key principles that arise from the case law to date. As the court's seen, there's been a lot of litigation on the topic of surveillance over the last decade. What I propose to do is to just give a very brief summary of what each of the key cases decided and when they were decided, to see how they fit into the picture in this case. And that's because some of the history of the litigation the Divisional Court was able to take into account, but some of it was not, given that there were 3 judgments, the earliest one stretching back to 2018. The fourth topic will be the European Convention on Human Rights grounds. As the court knows, there are 5 of them. The first one is the absence of safeguards for journalistic material and journalistic sources. It's pretty apparent from the judgment of the Divisional Court that the Divisional Court was relatively sympathetic to a number of the points made by the appellant and the National Union of Journalists on that issue. But ultimately, although the Divisional Court said that the direction of travel may be in the appellant's favour, it wasn't willing to preempt Strasbourg. Now, regardless of whether or not that was right, Strasbourg has now spoken on that issue and has confirmed that direction of travel. So as a result, we have a partial concession, but only partial, on ground 1, and the respondents have published some proposals, which are, we say, inadequate, to partially remedy the position. What I propose to do is to introduce that ground when we get there very briefly, but as he did below, Mr. Bunting will, with the court's permission, make the substance of the submissions on that issue, which is the same as occurred below. Ground 2 of the convention grounds is a failure to, we say, fix the defects that were identified by the Grand Chamber in Big Brother Watch. Again, there have been some limited and partial concessions since the Divisional Court gave its judgment, but we say those concessions are not sufficient to remedy the unlawfulness identified in Big Brother Watch. A particular reason for that is that the concessions that have been made only cover one of the bulk powers, bulk interception, and not any of the other bulk powers, such as bulk equipment interference or bulk acquisition, which we say need to be treated the same way in terms of safeguards. The third convention ground is about foreign sharing, and we say that the arrangements in the Investigatory Powers Act for sharing information with other foreign intelligence agencies, again, don't meet the requirements set out by the Grand Chamber in Big Brother Watch. In fact, if anything, the position has worsened since RIPA was repealed and replaced by the Investigatory Powers Act. Ground 4 is the bulk personal data sets regime. That's a new scheme in the Investigatory Powers Act covering the retention of and access to large data sets. With your permission, Mr. Heaton, who sits behind me, will make submissions on ground 4. And then ground 5 is the protection of legal privilege under the Investigatory Powers Act, which again, Mr. Heaton will make submissions on with the court's permission. Then there are 3 EU law grounds, all of which I'll be addressing, the government has elected to keep all of the key EU law provisions in place as retained EU law. So in particular, the e-privacy directive is retained EU law and has not been altered as a result of Brexit. And given the date on which this case was issued, which was quite a long time ago now, Parliament has also decided this case is one in which the Charter of Fundamental Rights should continue to apply. And that's relevant to some of the issues which arise. The first EU law ground is that EU law distinguishes between two different types of surveillance regimes. Schemes which are what the case law in the Court of Justice calls a general and indiscriminate scheme, and ones that are not. And the basic effect of that division in the case law is that a general and indiscriminate regime may only be used for national security purposes and comes with a particular and maybe lesser set of safeguards. So they're not prohibited, but they're restricted in the purposes for which they can be deployed, namely national security, and they have a different set of safeguards. In contrast, schemes which are not general and indiscriminate require greater safeguards, but they can be used for purposes other than national security, such as a criminal investigation. Those types of schemes require a fuller range of safeguards, including, and in particular, prior independent authorisation for access to the data. And that was the issue that was considered by the Divisional Court in 2018, where the Divisional Court decided that the arrangements for access to communications data without prior independent authorisation by the police and other non-national security agencies were in breach of EU law. As a result, there were changes to the Investigatory Powers Act, which we'll come to in due course, introducing a requirement of prior independent authorisation. And that is in practice carried out by an organisation called OCTA, the Office of Communications Data Authorisation, which operates under the Investigatory Powers Commissioner, Sir Brian Leveson. So the first EU ground is whether the bulk powers in the Investigatory Powers Act are properly to be described as general and indiscriminate or not, and if they are, what the consequences of that are. There is a sub-point on ground one in relation to one of the bulk powers only, bulk personal data sets, where the respondents also take a point that the entire bulk personal data sets regime is outside the scope of retained EU law. That's a point which they only take in relation to data sets, and I'll address that. So that's the shape of ground one on the EU law issues. Ground two on the EU law issues deals with the effect of the Court of Justice's case law about accessing material for criminal investigative purposes. And I've already said that such schemes generally require prior independent authorisation, and that is in practice occurring in relation to communications data. However, initially, the intelligence services, when they were carrying out a purely criminal investigation or purely criminal work, and they do such work, quite extensive work, they did not obtain prior independent authorisation. And in 2022, the Divisional Court decided that those arrangements were unlawful. They were contrary to retained EU law, and there is no appeal from that decision by the respondents. The issue in dispute on ground two before this court is that that acceptance does not extend to any of the bulk powers. So if the bulk powers are being used to obtain information purely for criminal investigative purposes, no prior independent authorisation at the moment is needed for access. And we say that is contrary to retained EU law. And we say that because, in essence, it's a matter of form, not substance. That where the same data is being obtained for the same criminal purposes, exact technique being used is neither here nor there. That's ground 2. The third EU law ground is a short one and goes only to the issue of relief. Because if the claimant succeeds on some or all of the European Convention on Human Rights grounds, the remedy in this court is likely to be a declaration of incompatibility, which of course triggers a power for Parliament, if it wishes to make a remedial order, but no more than that. But if the same defects are also breaches of retained EU law, the court itself has the power to provide a remedy. And that's because the principle of supremacy remains a principle of retained EU law, and it results from the choice of Parliament to maintain the principle of supremacy. And the position we're in today is that it's actually common ground as a result of the concessions made by the respondents that there are ongoing breaches of the European Convention on Human Rights. And we say the same points are also breaches of retained EU law, and the court can and should provide a remedy for those itself. What the Divisional Court said and decided was that the Convention didn't provide any minimum baseline under the Charter. But we say that's wrong in law, but nonetheless we say the Divisional Court didn't consider the actual question, which is, has EU law been breached? And we say undoubtedly it has been, in respect of at least the matters that are now conceded by the respondents. And the question ought to be what the remedy should be. So that's an outline of where I'm going in relation to all of the submissions. Before I turn to the Act, can I just make a couple of introductory points? This case has recently celebrated its 5th birthday without a party. That reflects some of the complexity of the underlying legislation and also a range of other litigation that's been going on alongside this claim. But it is actually possible to identify a small number of themes and issues which run through all of the grounds of appeal in this case. As you've just heard from that summary of the grounds of appeal, this is not a generalised attack on the Investigatory Powers Act, whatever my learned friends may say in their skeleton argument, nor is it an attack on the existence or the lawfulness of any of the powers that are in it. And that's because, as the Grand Chamber in Big Brother Watch made clear, the choice as to which surveillance powers ought to exist is ultimately a question for a democratic legislature. Different policy views may, of course, legitimately be taken, and that isn't an issue which the court is asked to resolve. The but is that the minimum level of safeguards required for using the most intrusive types of investigatory powers, especially bulk powers, is a question about which the Convention and retained EU law have always had a great deal to say. And the task which the appellant seeks to adopt in this case is to try and align the Investigatory Powers Act with the safeguards that are required, we say, by the Convention and retained EU law. And there has already, as you've already heard, been significant progress in that aim. The Office of the Communications Data Authorisation last year considered over 200,000 applications. The issues in this appeal now primarily concern the bulk powers. And the nature of a bulk power is significant because it's very different from the traditional idea of interception and surveillance being targeted on a particular person or a particular group or a house or premises. Instead of identifying a particular suspect or a person of interest or a place of interest and then investigating that, bulk powers operate differently. The aim in the first instance is to collect a very large volume of data indiscriminately. And I don't mean that in a pejorative sense. I simply mean that in order for the bulk power to be effective, one has to collect as much as possible. Inevitably, most of that data that's collected will have no intelligence value. But then the entire data set can be analysed for material of interest. And so the aim is to analyse as much data as possible, relating to as many people as possible, in order to find out who is doing things of interest, and to have a data set when someone of interest comes across your radar so that you can look up information on them very rapidly. So in a bulk regime, it's inevitable that particularly large amounts of information will be stored about people of no intelligence interest. And as we'll see when we get to the bulk personal data set provisions, that is actually part of the statutory definition of a bulk personal data set, that most of the data concerns people of no intelligence interest. And it's because of that nature of those powers that such regimes carry particular risks. And that's why the courts have found that minimum safeguards of high quality tend to be required, and there may be limits on the circumstances in which powers like that can be used. And the real common thread in the grounds of appeal in this case is how those safeguards ought properly to apply to the bulk powers in the Investigatory Powers Act. With that, my lords, can I turn to the Investigatory Powers Act?
Yes.
It seems to be in at least two places in the bundle, but I will, if I may, work off the version in the authorities bundle, which is tab 67, page 2642. This is a consolidated version, so it shows all of the amendments that have been made primarily as a result of the earlier stages of this litigation. What the Act does, and with apologies in advance, I think it would be useful to look at it as a whole in order to see its structure, and I can make quite a few of my submissions as I go along, that will make my submissions on the ground rather quicker, is it brought together and it developed much of the law on investigatory powers and surveillance. So it reenacts the existing powers that existed in the Regulation of Investigatory Powers Act 2000, RIPA, on targeted interception and bulk interception. That's not what they were called before, but the powers were there. It makes new provision for targeted equipment interference, or hacking, and bulk equipment interference. Those powers are there for the first time. It then consolidates the regimes for communications data and access to communications data.
Hold on, even quite quickly. There were new provisions on targeted and bulk equipment.
Yeah, so which didn't exist in the legislation before.
Yeah.
When those activities were being carried out previously, they could have been carried out under warrants under the Intelligence Services Act, but there were no bespoke provisions.
Yeah.
It consolidates the provisions in RIPA and also in DRIPA, the Data Retention and Investigatory Powers Act, on communications data. And then finally, there's a brand new regime for bulk personal data sets, which has no legislative predecessor. The legislation also covers some of the ground, but not all of the ground, of the Police Act 1997 for police property warrants, and the Intelligence Services Act 1994, which I just mentioned, for intelligence service property warrants. But it doesn't replace those bits of legislation. The purpose of the legislation was to modernise and improve the legislative scheme, and it reflected the key recommendations that were made by Lord Anderson, King's Counsel, in his Question of Trust report, which was commissioned after Edward Snowden's disclosures. And one of Lord Anderson's particular concerns is that the previous legislation, RIPA, was, as he put it in his report, incomprehensible to all but a tiny band of initiates. We can work out, once we've looked at this legislation, whether it marks a substantial improvement.
Well, we're not going to say now.
It starts off quite well, the Investigatory Powers Act, in sections 1 and 2, entirely sensibly, with an overview of the Act, and with some general duties in relation to privacy that I propose to look at first. But unfortunately, by the time we get to section 3, normal RIPA service is resumed once we get to the definition of interception, where it becomes extremely difficult straight away. I offer that again by way of an apology. It will be necessary occasionally to wade into the definitions, because the definitions are often very important to the scope of the act. So we're very grateful for the court's sensible suggestion of a glossary.
Yes, I think that's going to be a very valuable document.
So the structure of the Act is summarised in section 1. And subsection 1 is the purpose is to set out the extent to which investigatory powers can be used to interfere with privacy. We're then warned in subsection 5 that it's not a fully comprehensive statement of the law, and we will have to look in a number of other places, including in B1, the Human Rights Act, the Data Protection Act, the Wireless Telegraphy Act, the Computer Misuse Act, misconduct in public office, and helpfully in 6, Roman 6, elsewhere in the law. Then section 2 sets out the general duties in relation to privacy. I mention section 2 because it's offered by the Secretaries of State as an answer, or a potential answer, to what we say are some of the omissions later in the legislation. One has to be, we say, slightly careful about that, and that's because section 2 has quite a precise and limited scope. It covers, and this is subsection 1, any situation in which a warrant or an authorisation of various kinds is being granted or refused. The requirements of section 2 don't cover acts under the current law that don't need a warrant or an authorisation. Indeed, often that's the appellant's criticism. So that includes, as we'll see, an internal decision to select material for examination, or then examine it. And that can be particularly significant when dealing with journalistic material. The first set of substantive provisions are part 2, chapter 1, that deals with targeted interception warrants. Targeted interception warrant provisions start at section 15 on page 2656. And the concept of interception is unfortunately a term of art in the legislation that has already caused considerable difficulties. It caused difficulties in cases under RIPA, in cases about voicemail interception and phone hacking, and it's caused issues under the Investigatory Powers Act in cases involving EncroChat devices, which have been heard by the Court of Appeal's Criminal Division. But there's no doubt that whatever interception does or does not mean, it includes, for example, a phone tap, and it includes the equivalent of a phone tap in relation to internet usage. So to monitor internet usage or other forms of communication in the course of their transmission. And we're told in section 15, subsection 1, that there are 3 types of targeted interception, or 3 types of warrant that can be granted under section 15. A targeted interception warrant, C2, targeted examination warrant, C3, and mutual assistance warrants under subsection 4. So 2 is a targeted interception warrant that authorises the interception in the course of their transmission communications described in the warrant. That's 2A. And what's also authorised under 2B is the obtaining of secondary data from the same communications. So that's a classic interception warrant, phone tap, internet tap. The other type of relevant warrant for the purpose of this case is the one under 15(1)(b), the targeted examination warrant. That's a warrant that permits the targeted examination of material that's been collected under bulk powers. in particular the bulk powers of interception in Part 6, Chapter 1. Now, such a warrant is needed where you've already collected a mass of bulk data, but you wish to search for a person who is known to be in the British Islands. The British Islands being defined as the United Kingdom, the Channel Islands, and the Isle of Man. So as we'll see when we come to the bulk provisions, there is a prohibition on selecting for examination the bulk material by reference to some selector which will pick out, and you know and intend to pick out, someone who's in the British Islands. So using, for example, my mobile number or my email address in relation to bulk material would require a targeted examination warrant if I'm known to be in the British Islands. So that's the warrant under 15(1)(b). And that's explained in subsection 3. Then turning on to section 16, section 16 explains that secondary data can also be obtained. Secondary data includes, but is not limited to, what has traditionally been called communications data. And when we look at the bulk powers, I think that's probably the best time to look at the meaning of secondary data. So I'll come back to it if I may at that point. Then section 17 explains the scope of a targeted warrant. And section 17 makes clear that targeted warrants can actually be quite broad, or to use the language of the Code of Practice, thematic. So they can relate to, under 1A, a particular person or organisation, or B, a single set of premises, but also, under 2, an entire organisation, a group or a person with common purposes, or people carrying on a particular activity. Even multiple organisations, where it's part of what's described in 2B as a single investigation or operation. So, for example, a single investigative operation into a drugs trafficking ring would probably be authorised only by reference to a single warrant covering that operation. May cover a number of individuals, and the identity of the individuals will change, but that's the scope of that type of warrant. Under section 19, the Secretary of State has the power to issue the warrant, and then under 19(2)(d), the warrant has to be approved by a judicial commissioner.
Sorry, 19 what?
19(2)(d). That's the top of 2661. There's a requirement for approval by a judicial commissioner. That's except in cases of urgency. In urgency, there are other provisions which require the judicial commissioner to look at it very promptly after the warrant's issued, and the judicial commissioner can cancel it if he or she thinks that's appropriate.
So except in the case of urgency, the warrant has to have prior authorisation from a judicial commissioner.
Exactly. Yep. And a judicial commissioner has to hold or have held high judicial office, so High Court rank or above. And so all of the investigatory powers commissioners, judicial commissioners, currently hold or have held that status. Part 2, section 20 then sets out the grounds on which a warrant can be granted. And those grounds are set out in subsection 2, which is necessity in the interest of A, national security, B, preventing or detecting serious crime, or C, the economic well-being of the United Kingdom, so far as those interests are also relevant to the interest of national security. And then there's a further limitation in subsection 4, that the economic well-being power can only be used in relation to people outside the British Islands. So a targeted interception warrant can be used for pure national security purposes, pure criminal purposes, or economic well-being purposes, or a mixture of them. So targeted interception warrants can be and are obtained by the police for policing purposes. Section 23 on page 2665 deals with the role of the Judicial Commissioner. And under subsection 1, the Judicial Commissioner has to review the Secretary of State's conclusions as to necessity and proportionality. And in subsection 2, applies the same principles as would be applied on an application for judicial review. And B, consider the matters with sufficient care so as to ensure that section 2 has been complied with. So in essence, Judicial Commissioner approval is a form of automatic prior judicial review. That procedure, as the court will know, is new. Previously, warrants under RIPA were issued by the Secretary of State and there was no procedure for prior judicial approval. And it reflects the recommendations that were made by Lord Anderson to that effect. Then the legislation provides particular safeguards for particular groups. And the ones that are most in issue in this case are safeguards for legal professional privilege and safeguards for journalists. But the safeguards start at section 26, page 2668. The first safeguard is for members of Parliament and also members of, as we'll see from the definition, devolved legislatures. If there's going to be an interception warrant that's targeted at a member of Parliament or a member of another legislature, it requires the prior approval of the Prime Minister. So that reflects what Harold Wilson assured Parliament in statutory form back in the 1960s. Section 27 covers items subject to legal privilege. And I show you section 27 not because the appellant criticises it in this case, but to demonstrate a model of judicial authorisation. So under section 27, dealing with legal privilege, there is no bar in the legislation on obtaining privileged material. One can readily understand that there may be cases where there may be, for example, a national security imperative to interfere with legal professional privacy, perhaps on an urgent basis. But nonetheless, there are safeguards. So subsection 2, the application for the warrant must contain a statement that the purpose, or one of the purposes of the warrant, is to authorise or require the interception, or in the case of a targeted examination warrant, the selection for examination of items subject to legal privilege. So the warrant application has to say that on its face. And then under subsection 4, there have to be exceptional and compelling circumstances.
So you said the warrant had to say it on the warrant, or is it the application?
It's the application, my lord.
Yes.
I'm sorry,
Yes.
I'm sorry. It's the application for the warrant. Under subsection 4A, the warrant can only be granted if there are exceptional and compelling circumstances. That's A. And also that there are arrangements in place for the handling, retention, use and destruction of the item.
Could you just clarify one thing, because it comes back at times in. Under 4A, the issue can only take place if the person to whom the application is made considers that there are exceptional circumstances. And that is subject to review and authorisation by the Judicial Commissioner, who adopts the phrases used, judicial review. So basically, it's an irrationality. The JC must let it through unless it's irrational.
Well,
or to be struck down on public law grounds.
To be struck down on a public law ground. So that can include rationality, but also section 20 expressly includes necessity and proportionality.
Yes.
So if there is a public law failing, and that may include a breach of the convention, necessity and proportionality, the Judicial Commissioner can then strike down the warrant.
Thank you.
But of course, because they are public law grounds, that means that, for example, a question of judgment about what the interests of national security may require is likely to be one for the Secretary of State rather than the Judicial Commissioner. Whereas an issue of safeguards and about the adequacy and appropriateness of safeguards, given the convention case law, may be something that a judicial commissioner may need to pay more attention to when analysing the lawfulness of the warrant. But yes, there will be proper and appropriate limits on what a judicial commissioner can and should do. Not a de novo reconsideration. It's not the judicial commissioner's own decision.
Well, sorry, may I just give you one reference for that without unduly interrupting my learned friend? The Divisional Court in their ECHR judgment considered the question you've just asked, how does that work? Just one reference, which is to paragraph 44 of their judgment on the ECHR matters, which is core bundle tab 30, electronic page 903, effectively pointing out that if it was an HRA ground or challenge, that would be a matter for the court to decide for itself, and that had been accepted by me below, and I continue to accept that.
Yes, I'm very grateful to Sir James. So then those exceptional and compelling circumstances are defined in subsection 6. And there can't be exceptional and compelling circumstances unless A, the public interest in obtaining the information outweighs the public interest in confidentiality, B, there are no other means by which the information may reasonably be obtained, and in the case of a warrant mentioned or necessary as mentioned in 222B or 3, that's serious crime purposes, obtaining the information is necessary for the purpose of preventing death or serious injury. So what that means in practice is if the police wanted a warrant for the purpose of investigating crime and it involves the intrusion on privileged material, they could only get such a warrant for the purpose of preventing death or serious injury. That does not apply to national security warrants, where separate considerations apply.
So they couldn't get you to investigate a murder, but they could if it hadn't been committed.
Well, that would depend on whether one thought there might be further murders, for example. But one can easily see how that requirement might be met if there was someone at large. What it might not do is if you thought you had a suspect, to permit the police to intrude on that suspect's privileged communications with their lawyer after arrest, for example.
Yeah.
That might be one situation in which that has some relevance. Now, the effect of those safeguards means that on the face of the warrant application, there will be a warning that we are going after privileged material, which means that the Judicial Commissioner, when considering whether or not to approve that warrant, will be able to consider whether that's appropriate and the statutory tests have been met. So there will be prior independent consideration of the warrant, which considers the question of legal privilege. That's the effect of these provisions. And a very similar approach is taken in section 28 relating to confidential journalistic material. So subsection 2 is pretty much the same as section 27 that we just looked at. The application for the warrant must contain a statement that the purpose, or one of the purposes of the warrant, is to authorise or require the interception of communications which contain confidential journalistic material. And the same for a targeted examination warrant in B. So again, the effect of that is that the warrant application will say on its face that it involves confidential journalistic material, and the Judicial Commissioner will then be able to consider whether or not it's appropriate to grant the warrant, bearing that fact in mind. Section 29 covers the slightly different category of sources of journalistic information. And again, it contains the same provision in subsection 2. Application has to contain a statement that one of the purposes of the warrant is to identify or confirm a source of journalistic Judicial Commissioner will be able to decide whether or not that is lawful. Now, what's notable between section 28 and 29 is that there are two different sets of provisions. Section 28 dealing with journalistic material and section 29 dealing with sources. Now, journalistic material is defined in section 264.
So is section 28 confidential journalistic material?
Confidential journalistic
Yes.
material. Section 264 is the definitions of journalistic material, and that's on page 2925. And the basic definition is in subsection 2. It means material that's been created or acquired for the purposes of journalism. And there is then a deeming provision in subsection 3 where a person, R, presumably the recipient, receives material from another person, S, presumably the source, and the source intends the recipient to use the material for the purposes of journalism. The recipient is to be taken to have acquired it for those purposes. And so accordingly, a communication sent by the source to the recipient containing such material is to be regarded as a communication containing journalistic material. So that's the deeming provision for certain communications. And then there is an exception in subsection 5 that material is not to be regarded as created or acquired for the purposes of journalism if it's created or acquired with the intention of furthering a criminal purpose. And material which a person intends to be used to further such a purpose is not to be regarded as intended to be used for the purposes of journalism. Now, what that means is the subject of some dispute, and Mr. Bunting will make submissions on that. But it does mean that some material, at least, which the passing to a journalist of would be unlawful and criminal, may well be excluded from the definition of journalistic material. So, for example, material which engages the Official Secrets Act might be an example. It will depend on the meaning of intent and various other things, but that appears to be the type of situation which this provision is intended to carve out.
It would go very wide, wouldn't it? It would go to a drug dealer's tick list, for example.
Potentially, yes.
If he provided it then, or if it was then provided to a journalist.
Yes, potentially. Now, that can be contrasted with I'm about to give you a wrong reference, which I'm just going to check. Yes, that can be contrasted with section 2631, which is, contains further definitions. And on page 2923, there is a separate definition, about 2/3 of the way down, 2923, of a source of journalistic information. And it means an individual who provides material intending the recipient to use it for the purposes of journalism, or knowing that it's likely to be so used.
When all this, some of this derives, doesn't it, from the definitions derived from PACE.
They do.
And at the time when that was all drafted, we all knew what a journalist was, or we thought we did. But of course, times have changed now. So is there anywhere where one can find a satisfactory boundary?
The
maybe Mr. Bunting can deal with this in due course.
my my recollection is, of course, well, that, as my lady points out, the nature of what amounts to a journalist has changed. Is, for example, a blogger or a person who's particularly interested in the conduct of their local authority who writes
Well, you
a
now
blog.
have something called a citizen journalist,
Exactly.
and when people can put things on the internet, I mean, where's the boundary?
There is now some there is no statutory guidance, but I think there is now some guidance in the Code of Practice, which I'll take you to, or Mr. Bunting can take you to later, if we may. But I think the answer in the Code of Practice, as I recall, and I'm doing my best to memorise it, is that it depends on the circumstances and it depends on the extent to which the person is engaging in systematic activities which are designed to involve public reporting on issues of interest. It doesn't necessarily depend on whether or not the person is paid, because the person may carry out journalism without necessarily being paid for it. But the reason I show you the definition of a source of journalistic information is because it's different from confidential journalistic material, and it doesn't have that exception that we just saw for a criminal purpose. And the reason for that is because the Strasbourg case law has repeatedly made clear that, at the very least, when it comes to identifying a journalistic source, the fact that the source may be acting unlawfully is not a decisive factor when it comes to whether the source ought to be protected. It's a matter that may properly be taken into account, but it doesn't remove protection. And the reason for that is obvious, which is that whenever, for example, a minister or a special advisor leaks something to a journalist, which in reality occurs every day of the week, technically it's usually a crime under the Official Secrets Act, albeit one which is rarely, if ever, prosecuted. But the protections for those sources in the legislation do remain. So the upshot of that is that for the purposes of targeted interception, the commissioner, the judicial commissioner, is going to need to be told if there is an attempt to either obtain confidential journalistic material or identify a journalist source. And then the judicial commissioner will be able to apply the appropriate case law and decide whether such a warrant is lawful. Mr. Heaton has told me that what I did my best to remember out of the Code of Practice about the definition of a journalist is correct. And just to give my lady the reference, it's Authorities Volume 4, tab 76, page 3522, where there are a list of indicative factors as to what a journalist is.
Could you give me that?
Yes, it's Volume 4, tab 76, page 3522.
Thank you.
And that's the interception code. And just for completeness, the codes of practice do have some status because they're subject to public consultation and they're approved by Parliament. So that gives them an additional status under the legislation.
May I just check one thing? You say if it's the source, the exception relating to information for furtherance of criminal purpose doesn't apply, but it's the source of journalistic information, and if it's not journalistic information, isn't that the same for both the source and the recipient?
Well,
or is that what's being argued about?
Well, the point which is made by my learned friend Sir James and his colleagues is that there is a difference between a source of journalistic information and confidential journalistic material. And the carve-out in subsection 5 doesn't apply to that, because otherwise, and they make that concession because otherwise they have a difficulty. And the difficulty is that the mere fact that the source may be acting unlawfully may remove the protection. And that's why there are two different sets of provisions in section 27 and 28 relating to the two different categories, confidential journalistic material and journalistic sources.
It's not journalistic sources, it's a source of journalistic information, but that's their problem, not yours.
Yes. I think they draw a distinction between journalistic information and journalistic material.
Oh, I see, yes, okay.
We say if they're wrong about that, that makes the defects all the more serious.
Yeah, exactly, it's their
but-
problem, the judge, but disinformation material, I see the words now that are said to give rise to the issue. Thank you.
I'm
Sorry.
afraid it's a classic Investigatory Powers Act problem that you have words that are extremely similar, which have entirely different meanings. And so when we come on to the bulk powers, there's a difference between protected information and protected data.
Yeah, it's my fault. I had.
No, I'm afraid we've all been there, and in my case, more than once. So those are the targeted interception powers. Then communications data is dealt with in Part 3. So these provisions are provisions which have been substantially changed as a result of the Divisional Court's 2018 judgment. So what happened in 2018 is, as the Court knows, authorisations, unless they're urgent, or unless they only seek very limited information, such as subscriber data, have to go through the Investigatory Powers Commissioner, who operates through the Office of Communications Data Authorisation. So just to pick up those provisions, they start at section 60, subsection A, which is on page 2704. So, section 60A, subsection 1.
Sorry, I'll have to give me that reference again. Did you say?
It's section 60A, capital A, on page 2704. So, we've just looked at powers to obtain content through interception. There are then powers to obtain communications data. 60A gives the Investigatory Powers Commissioner power to grant such an authorisation. That's subsection 1B, Roman 1, and it's for the purposes of a specific investigation or a specific operation. So it's a targeted power, targeted in quite a similar way to the targeted interception powers. Then subsection 2 allows the Investigatory Powers Commissioner, who operates through OCTA in practice, to authorise the relevant public authority to obtain the information, almost invariably by going to a communication service provider and asking them to hand it over. And then over the page on subsection 7 is the list of purposes for which information can be obtained. And it's a relatively long list, which, as the court can see, is wider than the purposes for interception. So it includes public safety, preventing death and injury, to assist in identifying people, and so on. Then the effect of subsection 8 is to define what's called the applicable crime purpose. And that explains and imposes some limits on what can be obtained for the purposes of criminal investigations. And so A, where the communications data is wholly or partly events data, it has to be for the purpose of preventing or detecting serious crime, as opposed to non-serious crime. We'll come to the definition of events data in a moment, but events data is very broadly what people are doing on a communications device. So who I've called, when I've called them, where I was when I called them. And then B, in any other case, simply for the purpose of preventing or detecting crime or preventing disorder. So it doesn't have to be serious crime. The other type of communications data is very broadly what's called entity data, or sometimes in the past it's been called subscriber data. So it's who the person is that's using the network, which is inherently less sensitive. It's the name of the subscriber to a particular phone number, for example. So the Investigatory Powers Commissioner has power to grant all of those authorisations. And then there are the provisions in section 61 which allow senior officers to authorise without going to the Investigatory Powers Commissioner and there are then some schedules or regulations which set out the extent to which senior officers can act alone. I'm not going to take you through those, but the effect is that senior officers can obtain entity data for themselves, so find out who the subscriber of a phone number is without going to the Investigatory Powers Commissioner, and they can also act in urgent cases without going to OCTA.
You're not challenging this, are you?
No. Again, the reason why I'm showing you these targeted provisions is because they contain specific provisions relating to legal professional privilege and journalistic source material, which we say can be contrasted with bulk provisions. So, the journalistic protections are at section 77. Heading of section 77, which is
what page?
I'm sorry, it's page 2728, my ladies. The heading of section 77 probably does enough, which is that Commissioner approval for authorisations to identify or confirm journalistic sources is what's required. And there is then a procedure which is set out for Commissioner approval to be obtained. And we say, of course, that is a significant safeguard. And the reason for that...
Sorry, which subsection? So sorry. Which subsection?
Section 77.
Yeah.
Subsection 1 provides that if a designated senior officer has granted an authorisation under section 61 to get communications data, and it's not necessary because of an imminent threat to life, in those cases,
then you need a judicial commissioner.
Then you have to get commissioner approval. And then subsection 5 sets out the basis on which a judicial commissioner may approve the authorisation, if and only if the commissioner considers that there are reasonable grounds for considering the requirements of this part are satisfied. And under subsection 6, the commissioner has to, in particular, consider the public interest in protecting journalistic sources and the need for an overriding public interest before such an authorisation is granted. Now we say the reason why those protections are there is that communications data is normally all you need in order to identify a journalistic source. You don't normally need to intercept the journalist's communications. If you want to know who the source is, all you need to know is who the journalist has been talking to. Normally the content of the communication has been published. You can find it on the front page of the newspaper. Who gave the content usually requires an analysis of the communications data. Very briefly then, part 4 deals with the retention of communications data. That's page 2739.
So part 3 is getting it, part 4 is keeping it.
Part 4 is the ability of the Secretary of State to oblige a telecoms provider to keep it
Yeah.
for a particular period.
Yeah.
So it's available to be obtained under Part 3 if needed. The critical provision is section 87, which I don't think I need to go through in detail. It's sufficient to say it's a discretionary power, and it enables the Secretary of State to issue a retention notice to a telecommunications provider requiring them to keep communications data for a specified period. And the notice has to be approved by a judicial commissioner. Then the final targeted power in the legislation before we turn to the bulk powers is Part 5, dealing with equipment interference. That's on page 2751.
Sorry, so before we get to Part 5, it looks to me as if Part 3 and 4 are the wrong way around. Part 4 is to tell the communications operator to retain it, and then after that you're going to ask them to let you have access to it.
That's right.
All right, okay.
It would be logical.
To 4 and then 3.
Yes, 4 is the
Okay.
retention, so it's available,
Yeah,
and then 3 is accessing it once
Yeah.
it's been kept. That might be more sensible, but that's not how it was done for whatever
yeah.
reason.
But I've understood the sequence.
That's correct.
Yeah.
Then Part 5 deals with equipment interference, page 2751. And the structure is extremely similar to the provisions for interception. And equipment interference is, of course, in common parlance, computer hacking of various kinds. So section 99(1), there are two kinds of warrants. There are targeted equipment interference warrants, see subsection 2, and there are targeted examination warrants, see subsection 9. And those are equivalent to the targeted interception provisions, targeted intercept warrants and targeted examination, where there's bulk data that you wish to examine by reference to someone you know who's in the British Islands. Then subsection 2 sets out what you can obtain using a targeted equipment interference warrant. And it includes A, communications, B, equipment data, and C, particularly general, any other information. I draw the court's attention in particular to A, communications, because the statute expressly says that this type of warrant can be used to obtain communications. Now, part of the respondent's case is that equipment interference is completely different, and so ultimately the same type of safeguards as identified by the Grand Chamber in the Big Brother Watch case are not appropriate. But in fact, the legislation permits equipment interference to be used for the same purpose as an interception warrant, namely obtaining communications. And in the modern world, equipment interference is used as an alternative means of getting hold of communications. Because intercepting a telephone call on the wire in the traditional way may no longer be feasible if, for example, the data is encrypted whilst it's being transmitted. Instead, as happened in the EncroChat litigation, the EncroChat warrants, it's necessary to interfere with the equipment at one end or another, or somewhere in the middle, in order to decrypt and obtain the information. So in order to do the equivalent interference, the equivalent investigatory power, it's often in the modern world necessary to use Part 5 equipment interference rather than the targeted interception powers. Now, that isn't just the appellant's case, although it is the appellant's case, it's also the respondent's position. If I can briefly just seek to make that point good by reference to the evidence that's been served below. the best place to take it from is Mr. Dix's witness statement, which is in the supplemental volume of the appeal, page 103, and it's tab 3 for those working on paper. In this section of his witness statement, from paragraph 179 on page 103, Mr. Dix explains this power under Part 5, and at 179 explains the importance of equipment interference. Then over the page, at page 104, paragraph 181, he explains the kind of things that may be done under Part 5. The last sentence of 181 is that more complex equipment interference operations may involve exploiting existing vulnerabilities in software in order to gain control of devices or networks to remotely extract material or monitor the user of the device. And then at paragraph 183, he explains that it may be necessary to use the powers in quite a broad, or as he calls it, thematic way. And the example he gives at the end of 183 is to conduct interference, the last two lines, on a thematic basis across multiple devices within one or more geographic areas to identify a perpetrator.
So interception is in the course of transmission, you get it, and if you can't for some reason during the course of transmission, you get it at the end where it's sent or the end where it's received. Is that it?
Yes. The difficulty with that, and this is why interception has caused problems, is that interception may also cover stored material. And so there is an overlap between the powers.
Okay. So
just to explain how that works in practice, it might be useful for my lord to have a look at section 3 of the Act, which is on page 2645. And subsection 1 defines interception. You intercept a communication in the course of its transmission, if and only if a person does a relevant act in relation to the system, and the effect of the relevant act is to make content available at a relevant time to a person who's not the sender or intended recipient. Ignoring what content means for now, relevant time is then defined in subsection 4, and the relevant time extends to A, any time while the communication is being transmitted, so while it's on the wire, but also B, any time when the communication is stored in or by the system, whether before or after its transmission. Okay. So it's possible to get an interception warrant over an email once it's arrived. So if I send an email to Mr. Bunting's Gmail account, it will sit on that account, possibly for some years, even after it's been read. And any time whilst it's being stored by the system, it can be subject to an intercept warrant. And so therefore interception can extend over a long period. That would be one way of obtaining it. The warrant would then be served on Google, and then Google would have to give access to the account. Another way of obtaining access to the same material would be a targeted equipment interference warrant, if the material was encrypted and couldn't be obtained more simply by a warrant. So there is an overlap between the provisions. Just to complete that point, if I could ask the court to go back to page 2751. Subsection 6 explains this overlap that I've just been discussing with my lord a little more. A targeted equipment interference warrant may not authorise or require a person to engage in conduct in relation to a communication other than a stored communication, which would constitute an offence under section 3.1, unlawful interception. So you can't use the hacking powers to obtain communications unless the communications are stored, unless they've landed somewhere. But of course, in practice, that happens routinely. So there is considerable and deliberate overlap between these powers.
Sorry, what happens routinely?
That a communication in the course of its transmission will be stored somewhere.
Either by
Stored somewhere.
Yes.
Yeah.
Either by the sender or the receiver, or both.
Or by a server in between.
Or by server in between, yes.
So when I send my email to Mr. Bunting, it will be stored on my phone, and my phone is part of the telecommunications system. It will be stored on Mr. Bunting's phone, and a copy will also, no doubt, be stored on the server, somewhere in between. So there are numerous stored copies continuously, all of which could be accessed under Part 5. By way of hacking.
Does any of this Act authorise, whether it's technically feasible or not, I don't know, interception en route? Or is it all targeted at stored material?
Traditional targeted interception and also bulk interception that we're coming to can be used to target information en route. So in the very old-fashioned sense, the putting the crocodile clip on the telephone wire. The modern equivalent of that can be and is authorised under the interception powers. It's done, of course, in a more technically sophisticated way, but it is done. And that is what happens in relation to bulk interception. The explanation of the bulk interception power given by the Strasbourg Court is that it ordinarily involves tapping fibre optic cables as they enter or leave the United Kingdom and taking a copy of all of the data which flows over those cables.
As it flows?
As it flows, exactly. So that's a classic interception type power. Even if that information is never stored, it can be obtained that way. So the reason, my lady, my lord, for that slight digression is simply to show that there is an overlap between the provisions, and the overlap is deliberate to enable equipment interference powers to be used where interception is not an option. Then the subsequent provisions of Part 5 are very similar to the interception powers, so I won't go through them, I'll just give brief references if I may. Section 101, the powers are thematic, so they can be used by reference to organisations or operations. Judicial Commissioner approval is required on the same basis, that's Section 108. And there are materially identical provisions for legal privilege, confidential journalistic material and journalistic source material in sections 112, 113 and 114. So those are the targeted powers, and they can be contrasted to what's in issue in this case, which is the bulk powers.
Can I just check the subject matter of the warrant is in 101? Will the application for the warrant necessarily include the reference to the person or group of persons so that the person receiving the application knows what the warrant is about?
The instrument of the warrant may be quite brief. The application may be quite detailed. The instrument of the warrant may simply record the power under which it's been issued.
But the application will tell you the organisations or the people.
The application has to provide that information, yes.
Yep.
And there are some detailed provisions as to exactly what the warrant has to obtain in some of in section 115, that I was hoping not to have to look at. But the table in section 115, subsection 3, which is on page 2769, explains what has to be included in the warrant. And that includes the thematic factors on the right-hand side of that table.
So by definition, the warrant will have, the application for the warrant
We'll have to explain that.
will have to explain that, so the person who's authorising it will know what those details are.
Exactly.
Yeah. Thank you.
So those are the targeted powers. Then there are the bulk powers. And if I can use bulk interception as the exemplar, that starts on section 136, which is page 2791. So under section 136, subsection 2, the first condition, condition A, is that the main purpose of the warrant, not the only purpose of the warrant, but the main purpose of the warrant, is one or more of the following: interception of overseas related communication, defined in 3, and obtaining secondary data from such communication, section 137. Then overseas related is defined in 3 as either A, communications sent by individuals who are outside the British Islands, or communications received by individuals outside the British Islands. So the primary purpose has to be obtaining communications where at least one party to the communications is outside the British Islands. That's the upshot. It doesn't need to be the only purpose. A secondary purpose, which is entirely lawful, can be obtaining communications of people in the British Islands where both parties to the communication are in the British Islands. Then condition B, which is subsection 4, sets out what can be authorised. And what can be authorised is interception and obtaining secondary data. And also under C, selection for examination of intercepted content or secondary data. And then D, disclosure of information which is obtained. So the new concept there is selection for examination. There's no definition in the statute of selection for examination, but there is a definition of examination. And that definition is on page 2924 in section 2637. Examination.
Sorry, can you give me those references again?
Yes, section 263, subsection 7, page 2924. And the definition of examination is a reference to material being read, looked at, or listened to by the persons to whom it becomes available as a result of the warrant. So it means a human being reading, looking at, or listening to some of the intercepted communications. So what does selection for examination mean? Well, it means exactly that. It means selecting out of the mass that has been obtained in bulk, for example, tapping the contents of an entire fibre optic cable entering or leaving the United Kingdom, which communications should be read, looked at, or listened to by a human. And that's usually an automated process. And the automated process may be conducted, as the Grand Chamber explained in Big Brother Watch, using what they call selectors. So a strong selector might be a particular email address or telephone number or a name, or it could be by reference to a selection of factors designed to identify people of interest. So so the use of particular keywords or evidence that communications were sent to or from particular places. Now, these warrants can also be used to obtain secondary data as well as intercepted content. And secondary data is a concept that only appears in the bulk powers. And the way in which it's defined, and this is relevant to one of the convention grounds, is in a way that is more intrusive than traditional communications data that we've looked at already. And in practice, secondary data includes quite a lot of the content of the communication. Now, to make that submission good, it's necessary to look at section 137, which is on page 2793. Section 137, subsection 3, contains a definition of secondary data. So secondary data in relation to a communication transmitted by means of a telecommunication system means any data falling within 4 or 5. And then 4 is systems data, which is comprised in, included as part of, logically attached to or logically associated with the communication, so systems data. And then 5 is what's called identifying data, which is A, part of the communication, B, capable of being separated from the rest of the communication, and C, if it was separated, would not reveal anything which might reasonably be considered to be the meaning of the communication. And then with an exception, disregarding any meaning arising from the fact of the communication or any data relating to the transmission of the communication.
There was a note that was done for the hearing, one of the hearings below, on the from the Secretary of State on systems data and identifying data. Presumably that still holds good as the position.
It does, and I'm going to use that note to illustrate what these provisions mean, if that would be helpful. The reason for that is that these aren't straightforward provisions.
No.
By any stretch of the imagination.
What does logically associated mean in this context? Or is that a question I shouldn't be asking?
It's a question you can ask. I suspect there is quite a lot of sensitive technical detail behind the answer to it, which I won't know and I can't give.
But is it defined in the statute?
No. What I can do is I can try and give an example of what the appellants think it might mean in practice. Let's say, for example, that we have a packet of data being sent over the internet which contains an email. Identifying data which is comprised in, included as part of, attached to or logically associated with the communication might be the identity of the sender or the recipient, so the sender and the recipient's email address. It's logically associated with the communication. It forms part of the package of the communication. But also, under 5B, it's capable of being separated. You can scrape out the sender and recipient's email address. And if it was separated, it wouldn't reveal anything which might be considered to be the meaning of the communication. It doesn't tell you what's in the email, just tells you who it's from or to. So that's what we understand it means. It may well become quite complicated when one starts looking at things more complicated than emails. But as a very simple example, that's the best, I'm afraid, I think I may be able to offer.
Why wouldn't the word communications include those things, the email address from which it's sent and the email address to which it is sent? Why does it have to be secondary data, or could it be both?
It can be both.
It can be both, but there's a special subset Venn diagram definition for identifying data, is that it?
Yes, that's right.
Yeah.
And the reason this is relevant is that content receives more protection than secondary data.
Yes, reading what they're saying to each other, let's go and do something dreadful, and who sent it, and when it was sent might be different.
Exactly.
Yeah, okay.
Exactly like that. So the definitions, if I could just go to them briefly before going to those notes that my lady refers to. The definitions of systems data and identifying data are in section 263 subsection 4, and that's on page 2924. Systems data is defined in subsection 4 on page 2924. And it means any data that enables or facilitates, identifies or describes anything connected with enabling or facilitating the functioning of any of the following. And then there's a list of things. And then B is the telecommunication system, including any apparatus forming part of the system. That would include the mobile phone. Any telecommunications service provided by means of a system, so that might mean a communications app like Gmail or WhatsApp, a relevant system, including any apparatus forming part of the system, and any service provided by means of a relevant system. So very broad. So anything connected with enabling or facilitating the functioning of all of those things is included in systems data. And then section 261, subsection 6, contains a further relevant definition. 261.6 is on page 2919. We are told in subsection 6b, anything which is systems data is not content. So anything which...
So I haven't got that. Which subsection?
Okay, it's page 2919.
2919, yes.
And we're looking at section 261, subsection 6, which is a definition of content. And content is...
Oh, yes. Anything which... I've got it. So sorry.
Anything, and then subsection B contains a carve-out. Anything which is systems data is not content. Now, you have to do the slightly painful exercise of tracing through the definitions in order to work out what's going on. But the upshot is that if you have systems data, and if something that in ordinary language you would call that the content of the communication, if it is systems data, then it's deemed not to be content, and it doesn't receive any of the protections that we'll see for content.
Can you give us an example?
Yes. So the examples are in the supplemental bundle at just give an example. Tab 6, page 151. And if we just take example number 4 on page 152, this is a table that was prepared below by the appellant with the respondent's comments in the other column, in the second column of the table. So example 4 is the full universal resource locator of websites beyond the first slash, and then we give the example nhs.uk/contraception, and that is mostly agreed in principle.
So what is this?
Yes.
This
is an example of systems data,
which is not regarded as content.
which is not regarded as content and doesn't receive any of the protections of content. So, for example, the fact of the particular web pages that I'm looking at on the internet, as opposed to the website more generally, is now deemed to be systems data and does not receive the wider protection. And we give an example of the sensitivity of that. So it's not simply that I read the Times, it's the individual news stories I read on the Times. It's not simply that I've gone to the NHS's website, but the particular pages that I've looked at.
Can we just look at the defendant's response?
Yes. What they say is it's mostly agreed, subject to the introductory comments and the following points. They say it's a simplistic example, and it can contain a number of components, and they refer to the code of practice. And this may include queries, which help to locate certain content. Where there's an unstructured search data as part of a string, this is considered to be and treated as content. So what they're saying there is that the pages which I look at on the internet, they are deemed to be systems data. If I go to Google and I type in a particular search query, they will not view that as systems data. They will view that as content.
So the search term isn't systems data, but the page that the search term takes you to is systems data. Is that right?
That's right. That's their position. Now, we're not sure that's right on the definition of systems data, but that's what they've said they do. To give another example, example number 7. The fourth example we give is each swipe left or right on a dating app. So very granular, very sensitive personal information.
Hang on. Number 7, a data field.
Number 7, a data field, and then we give some examples.
Can we just have a look at it?
Yes.
Yes.
So, as my lady and my lords can see, there is a little disagreement about how a text field that one types into an internet site should be treated. The view of the respondents is, if I type a search into Google, that is not systems data. Now, to be frank, we simply don't understand that, because that is the data which actuates the system and which causes Google to carry out the search. And so, on our reading of the breadth of the definition, it clearly is systems data. But even if one assumes that they're right about that, there is no criticism of the other examples. And the activity which individuals carry out on the internet, which might in ordinary language be thought to be the content of what they are doing on the internet, the substance of it, choosing who to like and dislike on a dating app, which web pages to go to.
So the picture of the man or woman that you're looking at is systems data. The fact that you've gone left or right is also systems data, because there are two things there. Who's on it, and did you like them or did you not fancy them?
Yes.
And both of those are systems data?
Yes.
Right. According to them?
Yeah, we say they receive the lesser protection of
Yes,
systems
because
data.
they're systems data.
Now, the reason why I'm belabouring this point is because that's very different to what one might ordinarily understand to be communications data. It's not the who, where, why, when of who a person is communicating with. What it is it's the substance of the interactions on the internet. And as we'll see when we look at the provisions, this receives the lesser protection. That wasn't the case under the old legislation. Under RIPA, this would have all been treated as content.
I know you've taken us to the subsection, but is it possible to relate the examples to the wording of the subsection 4
Yes.
that we went through at speed? For those of us who are slower with the English language, catch up. In this act, systems data is any data that enables or facilitates or identifies or describes anything connected with, enabling or facilitating the functioning of any of the following.
And let's assume that the online dating site, because I don't think this is in dispute, is either a telecommunications service, a relevant system, or a service. The data which enables or facilitates or identifies or describes anything with enabling or facilitating the functioning of the site is the swipes, the choices. It also includes the URLs that the person types in or looks at on a web page.
Why doesn't it also cover the search term? Because that's what enables. But you say it does, do you?
We say it does. We don't understand the position which is adopted by the respondents. They say it's slightly narrower. I think that may in reality be some form of extra statutory concession because they don't like how far that goes. But we say on a plain reading of those words do not provide that degree of protection for search terms, which would ordinarily be considered as content. And when I make submissions on this point, I will just briefly compare these provisions with RIPA, where the controls are much more substantial. We say the upshot of these provisions is that Parliament has decided to reduce the protections given to content by deeming lots of things that people do on the internet, which may be very sensitive, not to be content.
Because looking at subsection 4, I wouldn't read that as covering the photo of the person on the website.
Well,
any data that enables or functions or identifies or describes anything connected with enabling or facilitating the functioning. And that's not the things that are stored there, is it? It's the things that cause you to have access. So you wouldn't have the photograph of Doris, you'd have, I don't know, whatever you type in.
You would have the photo of Doris. And the reason for that is that the way the photo of Doris is displayed is there will be a file name which is sent across the internet saying, for the next photo to be displayed, please look at this location on the internet. And this is the name of Doris's photo. It's Doris12345. And that will be systems data because that's necessary for the functioning of the system. And so the unique identifier of that photo and where it can be found on the internet will have to be included.
Right.
So we say it is actually a rather broad provision in its effect.
There's anything to make you go through the various sites that you're looking at as well as just typing in the initial search word. It's the moving on.
Yes. Because normally we don't type in a full URL. What we do is we click and the computer goes to the URL. Each of those clicks and the page references and data behind them will be systems data.
Yeah.
So just to make good what protection or the lack of protection for such material, if I could go back to section 138, that section, page 2793. Section 138 is the power to issue bulk interception warrants. And under 1 subsection B, the Secretary of State can grant such a warrant on national security grounds, or on that ground, national security grounds, and on any other grounds falling within subsection 2. And subsection 2 refers to serious crime and economic well-being. So it can either be national security alone or national security plus those other grounds. So it is possible to use bulk powers for criminal investigative purposes. Then subsection 1D requires the Secretary of State to consider that each of what are called the specified operational purposes, C142, is a purpose for which the examination of intercepted content or secondary data obtained under the warrant may be necessary. So there's a requirement for operational purposes. I mention the operational purposes because part of the Secretary of State's case is that the existence of operational purposes is sufficient to meet one of the requirements identified by the Grand Chamber in Big Brother Watch for specification of selectors. They say operational purposes does that job. Then subsection G, there has to be judicial commissioner approval. And then the procedures for approval are in section 140. It's the same provisions as before. It's a judicial review test. Section 142 on page 2796 then sets out the operational purposes requirement in more detail. And we can ignore 1 and 2, but subsection 3 says it has to specify the operational purposes for which the content or secondary data may be selected for examination. And then subsection 4, the operational purposes have to be taken from a list maintained by the intelligence services. Subsection 5, the warrant can specify all of the purposes if it wishes to. And then subsection 6, the list of purposes have to be approved by the Secretary of State.
Do we have the list of operational purposes or a list of operational?
No, the actual list of operational purposes is, we understand, sensitive, and so it hasn't been disclosed. Some of the operational purposes that have been used in the past were disclosed in the Big Brother Watch case in the Grand Chamber, and I'll show you them if I may when we get to that authority. But they include things like international counter-terrorism. So they are in very broad terms, and sorry, they weren't operational purposes at the time. They were under RIPA, so they were called grounds for certification. But they were in very similar terms, we understand, and they're very general. And that led to criticism by the Grand Chamber in Big Brother Watch that they were insufficiently specific. So that's why we say that this new requirement for operational purposes doesn't go far enough to meet the requirements.
You say it's the why, but not the what.
Exactly. And that is supported by subsection 7, which is the only provision explaining what an operational purpose has to do. Subsection 7 at the top of page 2797 says the Secretary of State may give approval for the operational purposes only if satisfied that the operational purpose is specified in a greater level of detail than the descriptions in section 1381B or 2. So the only requirement is it has to say more than national security, serious crime or economic well-being, but that's it. So international...
I'm being very slow about this, but is that saying it wouldn't be sufficient for the Secretary of State to give his approval, their approval, that they were satisfied that a purpose was the interception of overseas related communications? That would not be sufficient.
Yes, or that it was sufficient for the purposes of national security, which is one of the categories in section 138.
B 138 1B1.
Exactly.
So just that moniker would not be sufficient.
That would not be sufficient. You'd have to say more than mere national security. So, to give a hypothetical example, the words international counter-terrorism would be sufficient to satisfy that requirement. It tells you more than national security, because there's more to national security than counter-terrorism, and that's the only requirement of specificity. And then that would allow the examination of any bulk intercepted material for that purpose. So, those are the requirements of the warrant.
Look at 8 and 10.
My learned friend obviously suggests that we should look at subsections 8 and 10. First of all, at the end of every 3-month period, the Secretary of State must give a copy of the list to the Intelligence and Security Committee of Parliament. We agree that the Intelligence and Security Committee must see the list, but the only requirement as to its specificity is in relation to 7. The Intelligence and Security Committee don't have power to review or to cancel the list or to require greater specificity. And then 10 is that the Prime Minister must review the list of operational purposes. We agree that that is present. But again, the Prime Minister could perfectly well approve an operational purpose as general as counter-terrorism. So we say those are not meaningful additional safeguards when we come to the requirements of the law set out in the Big Brother Watch case. They don't touch the sides of those criticisms, we say. Section 152 contains the safeguards for examination, and this is where the difference becomes apparent between content, so defined, and secondary data. So, Section 152 subsection 1, says that there are 3 requirements for the purposes of section 150. And section 150 we don't need to look at, but it explains when material can be selected for examination and looked at. So 1A, the selection of the content or the secondary data is only for the specified purposes. And then B, the selection of the content or secondary data is necessary and proportionate. And then C, it meets any of the selection conditions in subsection 3. So we've got our mass of data, we've intercepted, for example, a whole fibre optic cable or numerous fibre optic cables. We've got a large data set. No human being can read all of that mass of data. There has to be a process of selection, and this explains how that process of selection has to be carried out. So under A, it has to be for the operational purposes, the specified purposes. And that's explained in subsection 2. The specified purposes means the operational purposes. And then the selection conditions in subsection 3 are important because they only apply to content. So section 3A, the selection of the content for examination doesn't breach the prohibition in 4. And then there are various other provisions we don't need to worry about. And then 4 contains what the parties call the British Island safeguard, that you can't select for examination if the criteria used for the selection are referable to an individual known to be in the British Islands at that time. And the purpose of those criteria is to identify the content of the communication sent by or intended for that individual. Now, these are horribly messy provisions that are right up there with some of the most difficult provisions of RIPA. But the effect of these provisions is to introduce a British Island safeguards in relation to content and content only. So in relation to, for example, the activities of me on the internet, if I'm known to be in the United Kingdom and the intention is to look at my internet usage, there would need to be a targeted examination warrant in order to go after that. It can't be looked at under these bulk provisions. If, on the other hand, what the agencies want to look at is not content, then all they need to do is to select for an operational purpose, which can be very broad, as we've seen, and the selection must be necessary and proportionate in all the circumstances. So the British Island safeguard is not present, and the British Island safeguard requires the approval of a judicial commission. Now, why does that matter? That matters because what is content and what is not content has been substantially changed, for the reasons I've already sought to develop. Because that safeguard, and we say it's an important safeguard, doesn't apply to secondary data. Even though, in reality, secondary data may contain the substance of the communication. Then there are, in the following sections, the provisions for legal professional privilege and journalistic material. In section 153, there are the protections for legal privilege. And it's only necessary to say that the safeguards are weaker than they are for targeted interception. And that's because what the agencies are doing is selecting for examination to get privileged material. They only need the approval of a senior official and not a judicial commissioner. Section 154 deals with confidential journalistic material. The safeguards are in practice less because, again, here the only safeguard is to notify the Investigatory Powers Commissioner when material is retained following the examination that is confidential journalistic material other than for its destruction.
Just going back to legal and professional privilege,
Yes.
I understand the point you make that it's a weaker safeguard, but connecting with what you've just been telling us about, the kind of material that's going to be secondary data sites on a website that you click to aren't going to be relevant, are they, for legal and professional privilege? Because isn't that going to be things like the advice or whatever that lawyers have been giving? So you've got to look at the likelihood, or do you have to look at the likelihood of whether or not the legal information, the legally privileged information, is going to be caught as systems data, not just if it were systems data, that it wouldn't be caught. I don't know if I put that clearly.
No, I do understand what my lord is saying.
Yeah.
Looking at section 153, subsection 1,
Yeah,
the first point is that such protections as they are, my lord already has my point about the not involving judicial commission approval,
yeah,
only apply to intercepted content. So stuff which is truly regarded as content under the legislation.
yeah,
So let's say a copy of counsel's advice
yes,
would be content.
yeah,
So if the intention is to look at the mass of bulk data because they know that counsel has sent his advice over the internet and so therefore it may well have been swept up, to look at that, to obtain a copy of that advice, then these protections will apply and they don't require judicial commission approval.
So if it's content, no JC approval.
Yes.
So it's not that it's systems data, even if it's content, if it's the advice or the instructions, the authorised official, not the JC looks at it. Is that
Exactly.
it? Right, okay.
And we say in relation to secondary data, the protection is even less because these safeguards don't apply at all.
Yeah, but it may not actually, legal information may not actually in reality fall into that. Yeah.
Well, that's the second part of my lord's question about whether or not privileged information will be included in secondary data.
Yeah.
Now, even leaving aside the points I've already made about the breadth of secondary data for a moment, there will be many situations in which even traditional communications data will reveal privileged information. And some examples are actually given. There's a witness statement, we probably don't need to turn it up, of Mr. Passmore, who wrote a book about privilege. He gives some examples in a witness statement he prepared from his own practice. One of them is the fact of someone having instructed a lawyer and the identity of that lawyer. So, for example, the fact, that an individual has instructed liberty, which often acts for and is instructed by people who claim to be whistleblowers.
Right, is the fact that you have instructed a lawyer legally privileged, and is the fact that you've instructed a named particular lawyer legally privileged?
It may be legally privileged, yes.
We're going to obviously go through the rest of section 153.
Just before I look at the rest of 153, just a final point in response to my Lord Justice Lewis. Another example of when material may be privileged is the identity in litigation of the witnesses who have been traced. And so that is classically subject to litigation privilege, whether or not a lawyer has been able to trace and make contact with a potential witness. And that's often very sensitive information. I mean, just to give a practical example, take, for example, the renditions litigation, most of which is settled, which has been brought in this country. The claimant's lawyers may well have traced and interviewed many of the individuals who were involved in other countries in alleged torture and mistreatment. Now, the fact that an individual has been traced and the fact that contact has been made between them and an individual's lawyers is privileged and doesn't have to be disclosed. In litigation, it's not necessary to disclose, and it is privileged who you've got in contact with as part of the investigations of your case. But even raw, simple communications data will reveal that. So there will be cases in which very sensitive information, which is privileged, will be disclosed by even traditional communications data alone, let alone secondary data. And we say there's no substantive protection at all in in section 153 for that. And just to finish on section 153 and to respond to my lady, the President's point, the effect of section 153, turn it up in my annotated version, is that there does need to be approval of a senior official under subsection 2, that the senior official needs to consider under subsection 3 the public interest in the confidentiality of the items, and the senior official may only give approval where there are, and this is 4b, exceptional and compelling circumstances, and exceptional and compelling is defined in the same way as it is in the bulk interception provisions in subsection 5. In essence, it involves issues of national security and the prevention of death and significant injury, and the importance of privilege has to be balanced in that process.
But you've got 9 as well. If you're not just going to destroy it, you've looked at it now, you realise it's legally professionally privileged. If you're going to retain it after examination, then you do need the IPC to look at it, don't you?
Yes, you do. And then one needs to one gives the Commissioner the power to make directions in relation to that material. But what it does not do is it does not prevent the privileged material from being targeted without prior independent approval. So it's always after the event.
It may be looked at without prior authorisation, and if it's destroyed, that's the end of it.
That's the end of that. If it's kept...
And if it's kept, then you've got to go back and get the IPC.
You've got to go to the Commissioner and ask for the Commissioner's approval, and the Commissioner has the power to either direct its destruction or to impose conditions. And the Commissioner will then consider a public interest test under subsection 12.
And is that because, until you look at it, you don't know that it's legally professionally privileged? I mean, why have they done it that way? Or do we not know?
I'm afraid we don't know, but we say the proper requirement is a prior approval.
Even if it's just looking at it to see it, it's not enough to say, oh gosh, once I've realised it's legal, destroy it or authorise it. You say it's got to be done in advance.
Well, one of the difficulties is if one is directly targeting privileged material, and that's the hypothesis we're looking at, once it has been selected for examination and read, it is very difficult to unread the information that's been obtained. So
why are you directly targeting it as... I mean, I understand you're directly targeting something, but why do you know that I want that legally privileged document, so that you're targeting it, rather than when you target information, you suddenly discover that the thing you've looked at is legally privileged?
Well, I understand the safeguard which is there if, looking for something else, one comes across privileged material, and then you go, oh, look, this is privilege. Okay, we'll stop reading now, and we will go to the Commissioner. The hypothesis of section 153 is set out in 1531B. And then, Roland 1, the purpose, or one of the purposes of using the criteria, is to identify items subject to legal privilege. So, the purpose of the selection for examination may be to directly go after particular privileged material.
Or 2, it's likely to identify such items.
Yes.
It's a solicitor that you're targeting, and he's likely to have stuff on his computer or her computer. Okay, but you say because the purpose can include directly targeting things, then you can't say this is the accidental check when someone's
can't say,
found.
oh, it's such a shock that that having constructed a search term of bulk data for example, a named lawyer and the name of the case that they're going on plus the word advice, we have come across some privileged material, and we've now started to read it, and only at that point do we go to the Commissioner. We say that provides obviously inadequate protection. That's not to say it can't be done and it mustn't be done. It may need to be done and it may be proper, but we say the appropriate safeguard, save in a case of extreme urgency, is that the Commissioner approves first because the Commissioner can, as we've seen from these provisions, introduce safeguards and restrictions as required to ensure that only proper use is made of the material.
Yeah, but latent within your submission is that it's got to be prior authorisation. If you take a step back and say, look at what's happening, and look at the protections overall, including the one at subsection 9, there may be a different argument. That's what we've got to look at. We mustn't automatically assume for Part 5 there's got to be prior judicial authorisation. That's one question, but there may be other questions. If not, are the other things adequate?
Well, that's right.
Yeah, okay, just so I got it, yeah.
I'm probably just a mile behind, or two. The whole point about bulk interception warrants is that they are limited by conditions A and B under section 136, and they're limited in their purpose by section 136. So, by definition, one of the purposes that entitles you to a bulk interception warrant is not a search for legal professional material. So all these additional safeguards, as I understand it at the moment, only come into play when, having got a bulk interception warrant under section 136 combined with section 136, you come across the example which you've just acted out. Oh, here is some legal professional privilege material. What do we do now? Have I misunderstood the position completely?
We say, my lord, that conditions A and B permit the recipient of the warrant to sweep much wider than that. That condition A only requires that the main purpose is the interception of overseas related communications and obtaining secondary data from such communications. So let's say, for example, that the object of the warrant is a particular group of fibre optic cables landing in Cornwall, and they transmit data to and from the United Kingdom from all parts of the world. That's the target of the warrant, and it's a bulk warrant. One can readily see how condition A is satisfied, because the main purpose of the warrant is the interception of overseas related communications. That is, where at least one end of the communication is abroad. Now, it may well be that a subsidiary purpose is also collecting communications of people between each other in the United Kingdom, because some of them may pass over that cable. But that's all that needs to be shown in order to meet condition A. And there will inevitably be substantial privileged material passing over that cable. And then condition B is simply that the warrant authorises various activities, namely A, the formal act of interception, so the tapping of the cable, B is the extraction of the secondary data, and then C is the selection for examination, the picking out of what's interesting, and then finally D, the disclosure. So one of the things that was said in the Big Brother Watch case is that the act of interception is likely to pick up a very large quantity of information, including communications about people of no legitimate intelligence interest. And because of that, what's important is the subsequent safeguards for selection, for examination, and also protections for lawyers, journalists, and so on. And that's because you're sweeping up so much. Contrast that with a targeted warrant, a traditional warrant, where you name number 5 Acacia Avenue as being the target of the warrant, or perhaps, if it's a thematic warrant, the users of a particular website, where it's much easier for a judicial commissioner to, at the start of the warrant, when you're considering granting it, to consider whether it's necessary and proportionate. Does this sweep too wide? Is this too narrow? With a bulk warrant, you collect as much as possible, and then the filtering and the protection has to occur later. And we say that's the principal difference between them.
But there's still filtering, but by a senior official. It's not the independent judicial authorisation that you would like, and which you say is required by Big Brother, but we've already got the fact that they've been doing this for the global criteria, national security and so on. Then, when they get to look at it, they realise that when they're looking at this, it's either likely or they're pretty sure it's going to happen, because that's the purpose, that it's going to be legally privileged material. and then the senior official has got to go through all those tests. So there are circumstances there. And if it's more than examination, if they're going to keep it, then there's got to be the IPC. So one has to bear all of that in mind. Unless there's an absolute requirement that, notwithstanding all the other safeguards you've got, there still has to be independent prior judicial authorisation once you look at it. That's your case, really.
That's our case.
Yeah, okay.
Then section 154 deals with the safeguards for confidential journalistic material. The sole safeguard there is to notify the Investigatory Powers Commissioner when material is retained following examination. There's, again, no requirement for prior approval of the Judicial Commissioner. And the absence of prior approval is particularly stark when it comes to journalistic material, because notifying the Commissioner is a bit late when the purpose of you doing this is to identify a source, and having identified the source, you can't unknow that information. It's shutting the stable door. And these provisions in section 154 only apply to confidential journalistic material. They do not apply to journalistic sources. There aren't the separate provisions that we have in the targeted intercept provisions, which provide protection for journalistic sources. Now that's important because there is no exception for where the source is committing criminal conduct in relation to the provisions on journalistic sources, but there are for confidential journalistic materials. Now, in relation to section 154, the Secretary of State concedes that section 154 is incompatible with the Convention and doesn't go far enough, following Big Brother Watch. What the Secretary of State has proposed is a remedial order, and I think it might be worth briefly looking at that, because in order to see exactly what's proposed to fix it. That's in the supplemental volume of tab 6, page 203. Sorry, it's not tab 6, it's tab 16, page 203. At page 208, there is a heading, the incompatibility. Picking it up 4 lines into the incompatibility, section 154 does not require independent authorisation for bulk intercept regimes. It only requires that the Commissioner is informed as soon as practicable following the interception of the material containing confidential journalistic material or where it's retained for purpose other than destruction. And then the Code of Practice determines that a senior official must be notified in advance before intending to select such content for examination. The European Court of Human Rights found that's incompatible with Article 8 and 10, and the proposed change will add additional robust safeguards and further enhancements to the protections for journalists and citizens. And then the new proposed section 154 is on page 213. And what is proposed is to take the type of provisions that exist for targeted interception and apply them to the bulk provisions.
Could we look at the part of the Grand Chamber judgment which made that finding?
Yes, of course. I was going to leave this substantially to Mr. Bunting, but I'm very happy to do it. So that's in Authorities, tab 56, and the court's analysis starts at page 2322. and the court's conclusions, the key parts start at page 2323, paragraph 447.
Well, you're going to start at 442, because this is all journalism, and it's Article 10 and the importance
Yes.
of Article 10, actually. Yeah.
The court goes through its previous case law.
Yeah.
It cites the importance of the protection of journalist sources, and then at 444 it cites its previous case law on the importance of prior independent authorisation before a source is gone after. Now, the Divisional Court in this case said that there was no clear and consistent line of case law requiring prior independent authorisation. We say that's simply wrong, and that's been confirmed by the Grand Chamber, but nonetheless we have this Grand Chamber decision now, so perhaps that argument doesn't matter so much. And then at 447, under the heading The Approach in the Present Case, under the Section 8.4 regime, that's the equivalent in RIPA of the bulk intercept regime, confidential material could have been accessed by the intelligence services either intentionally, through the deliberate use of selectors or search terms connected to a journalist or news organisation, or unintentionally as part of bycatch and bulk interception. And then 448 is the principles, where the intention is to access confidential journalistic material. And then the example is given the deliberate use of a strong selector connected to a journalist, or where the choice of such selectors has a high probability of selection examination. The court considers that the interference will be commensurate with searching the journalist's home or workplace. And that's regardless of whether the intention is to identify a source. The use of such selectors or search terms will be very likely to result in the acquisition of significant amounts of confidential journalistic material, and that could undermine source protection to an even greater extent in order to disclose the source. Cite their previous case law again. And then the test is the court considers that before the intelligence services use selectors known to be connected to a journalist, or which would make the selection of confidential journalistic material highly probable, must have been authorised by a judge or other independent and impartial decision-making body.
And are you saying the proposals don't go far enough?
We do, and the reason the proposals don't go far enough will be developed by Mr. Bunting. In essence, the proposals are limited to cases where the deliberate target is a journalistic source. It doesn't deal with the points made in paragraph 448 properly about cases where it is likely to lead to the acquisition.
Oh, this is the it's likely versus highly probable point.
So that's the difference between the parties.
There's nothing in what we've just read there dealing with a different topic now. There's nothing that we've read there that relates to or is directly transferable back to the protections for legally privileged material.
That's correct.
Yeah, okay. So I'm with you now. I thought they were using the journalistic ones to show the legal privileged ones were not right, but you're not doing that directly. You're doing the likely versus highly probable. Yeah. My fault.
The good news is we're close to being done on the Act, and I'll be able to make my submissions rather rapidly. The final parts of the legislation that are relevant are the bulk acquisition warrants, bulk equipment interference, and bulk personal data sets. And because of the similarities with bulk interception, I can take these rather more quickly. If I could go back to the legislation at page 2812 in the authorities. Section 158 contains the power for the Secretary of State to make a bulk acquisition warrant. And what those warrants are is explained over the page in subsection 6. A bulk acquisition warrant requires a telecommunications operator to disclose communications data which is specified in the warrant and in the possession of the operator.
Is that not content then? That's
not
whether,
content.
what, when, not the, what does it say?
Not secondary data.
Right.
That is a more traditional conception of communications data, the who, what, when.
Yeah. And this is what you get, is it?
And this is what you get. And so
you don't get content,
don't get content.
right? Okay.
So this is a warrant to acquire communications data in bulk from an operator. And the example is, for example, a warrant to require British Telecom and the mobile providers to disclose all of their communications data for all of the telephones on their network to the security and intelligence services on a rolling basis. And that is indeed the basis on which the predecessor power to this was in fact used. And that was considered by the Court of Justice in the Privacy International case. So it's a bulk power, but it's for communications data only. And it does not need to be overseas focused, like bulk interception. So there's no requirement that the main purpose be overseas communications. It can be domestically targeted. Now, because it's a bulk warrant, there are the same provisions as we've seen before for an operational purpose and judicial commissioner approval of the warrant. Those are in section 159 and 160. I don't think it's necessary to go through those. However, it is worth briefly looking at the rules for selection for examination. And there at section 172 on page 2825. So the selection must be for an operational purpose and necessary and proportionate, but there's no British Islands safeguard. And there is no provision for legal professional privilege, for confidential journalistic material or journalistic sources.
Well, British communications data, that's unlikely to be legally professional, legal privilege material, isn't it? It's not going to be the content, the advice, and so on. But I suppose you would say it's still the fact that you consulted a law, and you say that's...
It will be privileged in some cases.
Right.
And in relation to journalistic material, often the communications data will be all that's necessary to identify a source.
Because you know who the journalist has been talking to.
You want to know who the journalist has been talking to. You don't want to know the substance of the documents that pass between them because they will have been published. What you want to know is who the journalist has been speaking to, and that's what the communications data is valuable for. So the submission that we ultimately make is that the concession in relation to journalistic material has to apply to these other bulk powers as well as to bulk interception. Then there's chapter 3 dealing with bulk equipment interference, page 2828. This is simply a version of bulk interception converted with the small changes necessary to make it apply to equipment interference. Just as we saw the differences between part 2 and part 5, this is the same exercise done converting bulk interception to bulk equipment interference. And the reason why a bulk equipment interference power exists is the same reason why equipment interference power exists, because it may well be necessary to obtain information which can't be obtained by traditional interception, perhaps because, for example, it's encrypted. And again, just to make that point good, if I could ask the court to look briefly at Mr. Dix's witness statement for the Secretaries of State. It's in supplemental tab 3, and the relevant part is page 117.
paragraph 117.
Sorry, page 117, my lady, paragraph 221. And the important parts I draw the court's attention to are the end of paragraph 221, where it's explained that bulk equipment interference is a fast-developing alternative to bulk interception. And then at paragraph 222, Mr. Dix expands on the nature of the alternative and the similarities between the powers. So one might use a bulk equipment interference where it's not possible to any longer use bulk interception. So, for example, it may be necessary to interfere with equipment, and equipment can include the standard computer software that everyone uses in order to make material tractable and readable by the Security and Intelligence Service.
So I thought he was comparing something different here. I thought he was dealing part, chapter 3, part 6, bulk equipment interference, with part 5, targeted equipment interference.
Yes, he is dealing with that.
He's not comparing chapter 1 and chapter 3 of part 6, is he?
No, he's not comparing bulk, but he does say at paragraph 221 that it's a fast-developing alternative to bulk interception.
Yeah, but 222 is something different, I think.
222, he's also saying there's an overlap, that's right, between thematic equipment interference and bulk.
Yeah, and
because
thematic is not a thing that exists in law. It's a word that's added, as I understand it.
In the code, yes, that's right.
Yeah.
My lord's right. The substance of the provisions and the safeguards are essentially the same as they are for bulk intercept, although the names are slightly different. So, if it's convenient to the court, I'll take this slightly more quickly. Section 176 explains that bulk equipment interference can be used to obtain access to communications and also to any other information. It's a foreign-focused power, so it has the same restriction on overseas-related communications as you see in bulk intercept. And we've got the same provisions in section 178 for operational purposes and for the role of the Judicial Commissioner. And it contains the same British Island safeguard in section 193.
Section which?
193.
Thank you.
Instead of calling the British Island safeguard something which applies to content, section 193 applies it to what it calls protected material. The definition of that in section 193, subsection 9, means it comes to more or less the same thing. I don't think the difference is important for our purposes. And then in section 194 and section 195, on page 2846 and 2847, there are essentially the same provisions relating to legal privilege and journalistic material as for the bulk intercept powers. The difference is that the respondents do not accept that they need to change these provisions in the way that they've proposed in the remedial order. We say that is an unrealistic position in circumstances where bulk equipment interference is, as Mr. Dix puts it, a fast-growing alternative to bulk interception. The degree of interference to the person who is affected is identical. The exact technical means is neither here nor there. Then finally, bulk personal data set warrants, which are in part 7, page 2850. Bulk personal data sets are a little bit different to the other powers. They're defined in section 199(1) as being a data set which the intelligence service obtains, which includes personal data relating to a number of individuals, and then B is the critical part. The nature of the set is such that the majority of the individuals are not and are unlikely to become of interest to the intelligence service in the exercise of its functions.
Is this a sort of electoral roll type of?
It may be, it may be, for example, an electoral roll, an Oyster card database, a health database,
Aeroplane manifest, or, for example, it may include content. So it may include, for example, a copy of, for example, the emails which a particular company has sent or received. A data set can be extremely wide. It can be something as unexciting as an airplane manifest. It can be something as intrusive and sophisticated as a copy of an entire hospital's health records. It's a database where the majority of the people who are on the database are not and are unlikely to be of intelligence interest. And it includes personal data as defined in the DPA.
Yes.
Okay.
And that's subsection 2. So I've said that an example might be a database of health records. That's clear from section 202, subsection 2A.
Can you give me a page reference?
So page 2852. And subsection 2A requires that an individual warrant be obtained for a data set of health records as opposed to the use of a class warrant. So there are class warrant provisions for less sensitive information, the aeroplane manifest, and there are individual warrant provisions for potentially more sensitive data, and health records are one of those.
So this has already been seized under another power, and you're not complaining about that. But they want to keep it and look at it, and then you get into this. Is that it?
That's exactly right. It's a power to retain and then analyse data. It's not a power to initially obtain. So the warrants are granted under section 200, and I don't think we need to go through them. They have to be approved by a judicial commissioner. That's section 208. And we need operational purposes in exactly the same way, section 212. What we do have is we have some provisions for legal professional privilege. Those provisions are in section 222 at page 2870. And the effect of section 222 is to impose a new form of British Island safeguard. If the person to whom the search terms apply, when you're going after privileged material, is in the British Islands, you need Secretary of State and Judicial Commissioner approval. If not, then a senior official is enough. So we've got a hybrid here from some of the other provisions. What we don't have in Part 7 is any protections for confidential journalistic material or journalistic sources. Certainly no requirement for independent or judicial approval when targeting a journalist source using a bulk personal data set.
And again, the question would be, is it likely to be personal data? Because if it's not personal data, then the information is in court. So
let's assume that the aim is to unmask a journalist source. And let's assume that the journalist and the source are slightly more competent than many sources might be, and they leave their mobile phones at home. And the journalist is seen with the source in a cafe, and then the source walks off to a tube station, enters the tube and heads off somewhere or other. If you want to identify the source, the first starting point will be the bulk personal data set containing the tube travel records. Who entered the tube at a particular time and where was their card registered to, in order to identify the source.
You've seen the person and you want to find out what his name is or her name
For
is.
example, yes, to identify the source. And there are lots of ways in which that type of data set can and no doubt will be used to identify a journalist's source. And that type of data set is there because someone may not be carrying a mobile phone and you can't just collect their communication data and find out who they are that way. And so the protections are equally required. Just in 1 minute, if I can mention the final provisions in here. The only other relevant provision is section 225, which allows data which is obtained under another power to be converted into a bulk personal data set. And that means that, for example, a data set which has been obtained by bulk interception could be made into a bulk personal data set. And under subsection 5, the Secretary of State then has discretion to make provision to copy across some of the safeguards from the original mechanism by which the data was obtained. My Lady, my Lords, I'm about to move on to my submissions on the ground. Would that be a convenient way? I apologise for what has undoubtedly been a pretty painful morning.
That's very helpful, thank you. We'll sit again at